And lawyers, guns, and money.
Yeah, Garrett, now that you've scored, or I guess survived the, I guess, Supreme Court petition, and this case is now back on track for litigation, can you take us through some of the next steps? Has there been any discovery or merits discovery on this issue, or only class certification discovery, or was it a blend of the two?
Yeah, so we've completed much of discovery already. There have been over 100 depositions that have taken place. And so, you know, that was a long year or so of my life taking and defending a lot of depositions. And so we've completed a lot of the discovery. We will have to conduct a little more discovery. We need to wrap that up. But then a big thing is, you know, we'll have a status conference soon, and we'll plan out the rest of the case. The schedule for completing the rest of discovery. We'll have expert discovery. We'll have summary judgment briefing, and yeah, we'll get down the path of marching towards a trial then, and hopefully
is there a
sooner than later.
Yeah, is there a scheduling order that has been reset?
Yeah, that's something that will hopefully take place soon. You know, with the case on appeal for so long, it was stayed, and you know, we will have to have a status conference and get that all scheduled up. Okay, now I have one more. I know Dan is on deck, and I don't mean to take a third question in a row, but can you, I guess, explain what the critical liability issue is? I mean, I've read in the past about all these different exemptions that Major League Baseball is claiming. Is there an exemption, like the seasonal exemption, that's squarely at issue in this case that's going to be litigated? I'll give you an attorney answer. It depends, which nobody ever wants to hear. Since we're operating both under the federal law, which is the Fair Labor Standards Act, and we're operating under state analogs, there are different exemptions in play. And so now the result of our appeal is we have 3 classes under state laws. And so 2 of those classes cover spring training and all the other training that's unpaid that goes on in Arizona and Florida. Those classes are under Arizona and Florida law. Now, the nice thing about Arizona law from our perspective is that it doesn't have any exemptions. So the question is, are they employees? And if they are, then they should be paid at least the minimum wage. The third class that we have is under California law, and it covers a league that's called the California League. And it's a minor league that is an advanced Class A league, and it only takes place in California. And California doesn't adopt all of the federal law's exemptions either. And one of the exemptions the California law doesn't have is it doesn't have any seasonal exemption to it either. So, you know, California law, you know, we're going to be looking at, are they employees, which the face of the contract calls them employees multiple times. We feel like we're in pretty good shape there. And then, you know, they might raise another exemption or 2 also. So yeah, to give you an answer, and that's not a straight answer, I know, is it sort of depends by class.
So I kind of have, I guess, you know, we're all in here, we're under, you know, we're all attorneys. We kind of understand the mechanisms of class action certification. You know, I think it's important. We do have people that listen to this that are just, you know, sports fans. They want to understand how baseball is being changed. You know, obviously, and I guess I can provide some brief background. The class action certification was the only issue, to my understanding, that was up and decided on the Supreme Court, and the Supreme Court's ruling. At this point, Garrett, is the class closed? Can any other people still join this class and join this lawsuit if they were a minor league player that felt aggrieved?
Yeah, so under Rule 23, and for the attorneys out there, the exact provision of Rule 23 that we're using is Rule 23B3. And that provision of the federal rules is an opt-out provision. And so now that we have these classes certified under the state laws, all the players are automatically a part of those classes unless they choose to opt out during the notice period. So, you know, you guys, and I'm sure a lot of your listeners have received notices about class actions in the mail at some point where they say, you know what, you had a faulty lawnmower or something, and you're supposed to get $100 out of it or something. The same thing will happen here, where all of the class members will get a notice, and then there'll be a period of time where they can opt out if they so choose. If they don't opt out, then they're automatically a part of the class. They stay in the class. We represent them all the way through the rest of the case then. The odd thing, though, that makes this case a little bit more nuanced than a normal class action is that the federal law is actually different. The federal law has the opposite mechanism, where it's an opt-in mechanism under the federal minimum wage law. And so several years ago, players did have to affirmatively opt into the case for the federal law. And we actually had about 2,300 players opt in, which I was really, really happy about. Because, you know, a lot of minimum wage and overtime attorneys will tell you that those opt-in rates are usually pretty low because you're expecting a person who is sometimes still employed by the company to sign their name on something and to affirmatively do something. And so we were really happy that, you know, a number of current players, some players who are in the playoffs, by the way, or has signed their name to this thing several years ago. And, you know, we were really happy about that.
Yep. Now I want to close, or at least my last question is going to focus more on law firm economics and the delicate balancing act that's involved in assessing the settlement value of the case versus the risk of going trial. You've been at this in the trenches for the last 6 years. I imagine your law firm has devoted millions of dollars of soft attorney time as well as hard costs that can only be recovered if you win, settle, or have some type of, you know, common fund. Are you taking this case to a trial? Is there the principle involved of trying to upend the major league system of basically indentured servitude for minor leaguers, or is there a deal to be had? And how do you juggle, or you know, just how do you address those two competing, you know, tensions? Given the investment that your firm has made, it is a business. You're not, you're not here, just devoting this as a not-for-profit. Your firm is a for-profit law firm. At what point do you go for the best deal you can? Or is this something that you want to take to trial because of the way it could upend and potentially change the way minor leaguers are paid forever?
Yeah, so you're right. Our firm, Core Artillery, has invested a lot of resources in this case. But, I guess the way I would describe it is there are certain cases that you do to fund the firm. And then sometimes there's cases that you do because it's the right thing to do. And this case falls in that latter category. And so, me as a former player, I want to make sure that we do everything we can to do the right thing and get this done right for players. And so if that means that we need to take it to trial and we need to get a verdict, then that's what we'll do. If it means that there is some compromise that makes sense and that brings forth meaningful change, that's something we can take a look at also. But at the end of the day, whatever happens, it's going to be the best thing for the players. That's our obligation, and that's what we're going to do.
Yeah, if only you had represented retired NFL players in their battle with the league over concussions, man. Those attorneys,
oh, what a mess.
Those attorneys bailed.
I'm glad I'm not in that one.
Yeah, that's a disgrace. You're to be commended for your taking on Major League Baseball over more than a half a decade on this issue, with much, much more to come. And we look forward to following this case, closely, and having you back on, hopefully lighting a victory cigar, because it is, as much as I'm a fan of baseball, you can't accept the notion that you're rooting for your favorite teams in the playoffs, but they're owned by, billionaires, while the up and coming players who become the player, the few that make it, shouldn't overshadow the many, many more who never make it, that are paid way below a minimum wage, way below the poverty level. And it really does strike at the core of fairness and justice for our American workers. So I wish you a lot of success in the case, and congratulate you for taking it this far. You're almost there.
Well, thank you. I appreciate it.